for joining this webinar. My name is Nevia Agnes. I'm the co-founder of Majlis. And Majlis has been organizing, the main aim of Majlis is to provide legal support to victims of sexual and domestic violence. We're very happy to join in this effort to create awareness about child sexual abuse in our homes, in our surroundings. And the Majlis work is more into accessing the legal system after an offence has been done. Creating awareness about this crime in our society that goes on very rampantly is a very important part as a preventive measure. So there is a preventive measure and there is a curative measure. And Majlis works more on the curative measure in the sense of providing legal assistance after crime has been committed. Our concern is that there's a great apprehension about approaching the legal system. And a lot of time, even if the people around the child or who are the support base for the child are aware of the crime that is being committed, they're extremely hesitant to go to and complain to the police, to file a formal complaint. And more often than not, there's the lid put on this crime so that it does not come out, nobody comes to know about it. And that's extremely sad state of affairs. Though we know that child sexual abuse is there in our society, is there in our midst, it grows because those who are supposed to be in charge of the child hesitate to go to the police and to file the complaint. So the webinar today, organized by the Majlis Legal Center, is the aim of this workshop, the aim of this webinar is to create awareness about the law, to demystify the law, to explain what actually the legal provisions are, and particularly those which are beneficial to a child, both at the level of the police station and at the level of court during the trial. This information is not known to the public, and hence there is a fear, there is an apprehension about accessing these measures, which are put there precisely because a child needs protection, a child needs support from the time the crime is recorded till the trial. So the demystifying of the law is as important a factor as creating awareness about the crime. So we hope you will enjoy this and it will throw light on some of the misgivings that we all hold and clarify things so that this apprehension against reporting a crime diminishes in our society. So we do hope you will enjoy this conversation between our team members to explain what the law is, to explain and dispel some of the misgivings that we hold, and to make things very clear to each of you who are attending this workshop. Thank you very much.
Hello everyone. Good evening and thank you for being part of this really important issue and really being part of coming together to kind of bring an awareness to child safety. It's an extremely important issue for most of us, and all of us are grappling with how do we respond to this absolutely grave concern. As part of Child Safety Week, we at Majlis decided to get together. As you can see, we're sitting really close, but we have taken sufficient precautions to be able to do that. We thought it would be important, considering the topic is legal and it tends to get really heavy sometimes. A conversation about this would bring about more clarity to the issue. My name is Audrey DeMello. I work with Majlis. I head the Majlis Survivor Program on domestic violence and sexual violence. Um, and actually, since 2011, Majlis has been responding to cases of sexual offense. Uh, we were surprised to see when we started our work on sexual violence as to the number of victims that were children. And it shocked us actually initially because we believed that it was a crime against women, and we thought we will get some cases of children, but it turned out to be that almost 79 to 80% of our cases are those of children. Shortly after we started our work, we got the Protection of Children from Sexual Offences Act in 2012. It was a major breakthrough. And I say that because we have dealt with a number of laws as part of our work, but the Protection of Children from Sexual Offences Act 2012, which in short is called POCSO, was uh, was very innovative for its time. And why I say that is because it really broadened the definition of sexual offences at one level, but it introduced a number of procedures and a lot of thought went into framing of this law to ensure that children facing sexual offences would be provided the necessary support. The procedures at various institutions would be child friendly and victim centric, and it would be easier for children to access the system. Some of the beneficial provisions, as we know, is that childhood is defined as both boys and girls, and we do know that there are cases of boys who face sexual offences. The large majority are still girls, and one of the reasons could be that there is a lot of stigma around reporting both for boys and girls, but much more for girls. 18 was the age of consent, which means all children under 18 were defined as child and could report under the POCSO Act. It brought in a lot of conflict in a way that then any love relationship or a romantic relationship between a boy and girl under 18 was also scrutinized under this and was defined as a sexual offense. So there was a lot of doubt in people's mind as to how this would go about. But if you look at the other provisions, it defines sexual violence and sexual abuse in a very broad framework. It talked about the fact of not only penetrative sexual offense, but also molestation, sexual harassment, touching, stalking. All of these crimes came under the purview of the law. But what I found personally most beneficial within this law was the procedures. Procedures within the police station, procedures within the court, to make it child friendly, to make it victim centric, and to ensure that the child was protected at every step of the way. Sadly, we are now 8 years into the act, and that's a long time, but how much has things changed on the ground? Are people comfortable even today to report a sexual offense? And I think these are important questions. One of the work that Majlis does is provide social and legal support to victims of sexual violence. And we are there with the victim and holding her through the entire process from the time the case is reported right up to the end of the trial, not only through our legal intervention, but also ensuring that we look at her life in a holistic manner. And our motto and our line is transforming victims into survivors, to ensure that in some way her life, after having come in contact with us because of this grave tragedy, in some way can we help her to just come out of the situation and be able to live a holistic life. That has been our effort, and until today, Majlis has supported almost 1,500 victims of rape, and we bring to you that experience today when we have this conversation. I have with me two of my colleagues, Advocate Percy Silva. She was instrumental in starting the Rahat program, which is to provide the support to victims, and we've traveled this journey literally learning the ropes. She joined Majlis as a very young intern, student of law, and we had so many visions and so many hopes of what this program will do for victims. And she's been with this program throughout this journey. She has vast experience in both handling cases, legal cases of both domestic violence and sexual violence. I also have with me Jacinta, who is a lawyer, and she heads the Rahat program today with her team. And she too brings a lot of experience for the past 4 years. She's been struggling and engaging with the system at every step of the way. And I'm just happy to have this conversation with two people that I believe have engaged with the system the closest and have seen the system up close. So we can start our discussion. I think I'll start with the question to Jacinta. So one of the provisions, Jacinta, is that POCSO mandates that a victim does not need to go to the police station to report her case. They talk about a victim, where the police officer should be a police officer. She should be in plain clothes. This is what the law says. What is your experience of what is really happening on the ground?
So, thank you for the introduction, Audrey. And yes, we've experienced when we deal with a lot of cases with children. And yes, that's true. The child victim does not have to go to the police station. And the police officer has to be a woman police officer who is recording the statement. And also, it's important that the statement has to be recorded in the place where the child is concerned. So and also if a child doesn't understand the local language, then we can demand for a translator. And also if a child has a special need or is disabled in any way, we can get a special educator to get a statement recorded. Also, the police has to make sure that the child does not face the accused, because that's very important for the child to be comfortable. And of course, a copy of FIR is also to be given to the complainant and the victim free of cost. But at the same time, we have also experienced that our experience has been that when a child has not been comfortable, we have recorded the statement at the place where the child is really comfortable. I can tell you of a recent case where a 4-year-old child was not comfortable at home. I mean, we were using toys and doing other games, playing games with the child, but then we said, now what do we do? So we spoke to the child welfare committee, where the committee said, we can try recording the statement at the committee, at the CWC office. And there also the child was not comfortable, the police helped, and we all sat down to play some games. And while we were doing that, we slowly, started speaking about the incident, and the child started speaking. And the whole thing was recorded. We can also record the statement. So yes, we have experienced in most cases when we get involved, we make it very comfortable for the child. And it's also important that any cases that are reported, of course, so the police has to inform the child welfare committee. And especially in 3 cases, they have to produce the child to the child welfare committee, especially in cases where the child victim has no parents. And if any the incident has happened at home and the perpetrator is something from the home, and also in cases where abuse has happened in any institution. So yes, it is a very good benefit provision for children. And my experience has been that we have seen this happening.
So you feel that when there is an intervention, when there is a support, we manage to get this. Another thing, Jacinta, what I find is that, I'm sure participants on this webinar, but mostly people are really scared of the police. And one of the doubts that I have often heard is that if I report this case, how often will I be called to the police station? Because there is a lot of stigma attached to interacting with the police. And on some level, the victim wants to forget the incident and not be reminded. So how many times would she typically have to come?
So after the statement is recorded, of course, within 24 hours, the child has to go for a medical, and after that, the child, will be called for a statement has to be recorded. That is one, yes, TR. If the perpetrator is an unknown person, then a test identification period is done, and after that, also there's one thing that's called panchnama, where the child will be taken to the spot, to collect evidence or anything is used while, during this incident. And also after that, there's one statement which the child has to give in front of the magistrate. That is one statement under 164. After that, the child will be called to the court for evidence. So these are the, 4 or 5 times where the child will have to, come. The police will call the child, and it is, sad that the child has to repeat the incident. But yes, these are procedures which is.
Yeah, but it's interesting to know that, maybe three, maximum four times. And also, like you mentioned, all precautions are taken that it is done at her convenience and with complete confidentiality. I think that is a really important thing, because people have this vision that they will be constantly have to go to the police station, it will take so much time, etc. Regarding the police, I was just wondering that a lot of times when the accused is a powerful person, maybe from the community, and he is out on bail, we find that there is a lot of harassment by the accused to the family or to the victim directly. And that is a fear, and that's one of the reasons why people don't report that this person is powerful and they may come back to us. So, what is the precautions that a victim can take during such times?
Yeah, it happens in many cases, because after the bail, the accused thinks that he's free, and especially it's also because they fear and they want the victim to withdraw the keys. So they will try to get in touch with the victim and the victim family or threaten and make life difficult for them. But typically, what we suggest when we've seen that has really helped is that one, even if it is a small threat, to file an NC or file a police complaint. And if it continues, then we also, through the public prosecutor, the victim and victim's family can make an application to the court to, for the cancellation of bail. Because when the bail is granted, the condition, it's a, conditional bail, where, it is mentioned that the victim, the accused, should not, be in the vicinity or the area where the child is, or also should not confront the child or get in touch with the victim of the child at any point. And if any violation would amount to cancellation of bail. And we have done, most of our complainants when they come, they have followed this procedure, and this has really helped, and there has been cancellation.
That's really reassuring, because I think what I hear mostly in most groups and discussions is that there is a fear that if we report, we will be arrested. So versus just bringing in this whole thing about this fear of reporting, I think there was a lot of discussion, and one of the provisions that came about in this act was the clause of mandatory reporting. And there is a lot of mixed emotion connected to mandatory reporting. Organizations, individuals are fearful about mandatory reporting. I'm aware that Majlis has taken a stand that they are for mandatory reporting. So, just wanted to ask you, why?
Audrey, I think when the provision of mandatory reporting actually was brought into the POCSO Act, there was a lot of division even within child rights groups as to whether this was the right thing, whether it was not. But I think the background really was the child sexual abuse is one of the most underreported crimes. And because children don't have a voice, they don't have an agency, they don't have access. That is one of the primary reasons that because children lack that access and agency, crimes against children, especially sexual crimes against children, are so underreported. That being said, the criminal justice system can be an intimidating space. There is no doubt about that. And I think that it is important for us to understand that though there is a provision of mandatory reporting, any organization or any individual
that works on child sexual abuse has to implement the act, and you have to mandatorily report, but your responsibility doesn't end there. And we've seen so many cases where parents, teachers, social workers, counselors have been reluctant to report. And some of the main reluctance really comes from the fear of the system. The reluctance comes from, knowledge of the, or lack of knowledge rather, of the unknown. So when we have managed to create a safe space for them, when we have explained the processes to them, when we have explained the various options that are there, how is the legal system, how can they proceed further, then we have seen that there is certainly more acceptance to mandatory report. As we know, a large number of crimes are committed against children in their homes. Fathers, grandfathers, uncles, mama, chacha. And those are the cases where mandatory reporting becomes much more difficult, because if this perpetrator is this big bad man from outside, then there is a much larger chance that the family, for the sake of family honor or to punish the perpetrator, will be easily convinced to report, or may even approach the police station themselves and want to report. But when the perpetrator is within the home, that is really where we face challenges. And there have been cases where we've worked for days and for weeks, convincing parents, convincing the mother. One such case that immediately comes to mind was a case where a mother was a victim of domestic violence. Her husband was a drunk, and she was, the sole breadwinner of the family. And her father-in-law, who was the grandfather to the children, used to support her financially. And when the mother would go out and work, that's the time he would take advantage of the fact that his son was a drunk and would molest both the children. And it was when the elder child started realizing that the younger child was also being subjected to sexual abuse, did she confide in her mother. And I remember it took us 4 days to convince the mother to report. But she herself was a victim of domestic violence, dealing with her own trauma. How will I manage financially? Who will pay for the school fees? Will my father-in-law be in jail only overnight? So many misconceptions about the law. Will my child's, by the time my child gets married, then the evidence in the court will come up. So there were so many misconceptions, so many stereotypes. But we were lucky that there was a local social worker who referred her to Majlis. And through that constant support, we were able to provide that information to her. The police were called to our office. The children's statements were recorded in our presence. And when she realized that these beneficial provisions we were able to implement, she was that much more confident. And subsequently, we secured a conviction in the case against the grandfather. So I think that through sustained support, and moreover through explaining to people that what they always need and what they always see on TV is not necessary reality, it helps in overcoming this issue of mandatory report.
I'm curious to know how did she manage financially at the end, because conviction is definitely one thing that we're looking for. Like you said, she was also financially dependent.
Yes. So I remember earlier on, we had to help her with financial support for school fees, because school fees was something that her father-in-law used to pay for. She needed temporary shelter, so we had to connect her and her children to a shelter room where they could stay, because she did not want to go back, and though she had a right under the Domestic Violence Act to stay in the home, she did not. That was her choice. So temporarily to connect her to a shelter home, to ensure she and her children were safe, to ensure that their education was not stopped, to ensure the three of them received continuous counseling through this process. Then there was a fear in between that the grandfather may get bail because he was older, senior citizen, had medical issues. So how to overcome that fear? We helped her, I remember, get a skill, so that she was earlier a housemaid. So how she could improve her skills and get a job where she could earn more. So the entire time from the FIR until the judgment, that entire 2 year process, every time understanding her situation, and while following up the case in court and through the police in a sustained manner to identify what her other requirements are. Because if we had not provided that continuous support to her for 2 years, she would have not stood in court and not spoken against the father in law. Because there was so much societal pressure, pressure from her husband, pressure from the mother in law, financial constraints. So, unless each of those hurdles we helped her overcome, she and her children would not have spoken in court. And it was only because of their testimonies that we managed to get the conviction.
I think what you're really saying is that there is a need for a holistic support to victims if we truly want to help them, and mandatory reporting is just the starting point. And maybe not every organization or individual may be able to provide the entire support, but definitely they can connect her to organizations. There are many such organizations across this country who can provide the support. We also have the child welfare committees who can support the whole process. So everyone will have to do their duty if we need to bring this issue to light and also address this very great problem. I just want to now move on to a very important area that I believe is right in the middle, literally, of this whole sexual abuse case, which is the hospitals and doctors. They play a really important role, and I think NGOs have identified medical as a very crucial intervention and a very crucial role that medical should be playing in cases of sexual offense. I just want to ask you, in your experience in handling cases, how has the role of doctors been in providing support, and what can victims expect when they go to a hospital?
So, when the child is taken to the hospital, okay, if the victim is, the child is below, sorry, yeah, is below 12, the parents have to give consent. And if it is the child is above 12, you take the consent of the child. Now, medical is not only investigating into the incident, it is also about treatment. If a child says that, above 12 says that I do not want to consent, it's important that, the treatment be given to the child to see if she's, had some injuries, whether she has, there's a possibility any disease can be contracted, to look into that, and also whether there's, pregnancy that can happen. So it's important that that is looked into. So all this thing is, provided, and it should happen and happens. But there has been cases where, in one of the cases which we were dealing with, the child was very young, 4 years old, and was not allowed to touch her. So the mother kept saying that, we'll come back, or let's look at it a little later. But there was a situation where, in this particular hospital, they said, like, you have to do it now, or otherwise you go. Like, they made them sign some documents saying that the mother had decided not to get the medical done. So in those cases, we've seen, like some of the cases, we've seen that it happens. But the point is that also another thing that we experienced is that, even if the support, there are people who go with support, the medical has to happen, the child is suffering, they'll be sitting in the in the hospital for hours and hours, and it's delaying. So that has been, we have had good experience, but we've also had these kind of experiences, and we have raised these issues with the hospital, and we have written, supported the family to write the letters to the appropriate authorities, and actions have been taken. But important thing is that the treatment has to be done, even if the child says no, or gives no consent. And also, it's important that another thing important is that no hospital can deny medical treatment.
Treatment is of prime importance, and I think that's where we talk about a victim-centric approach. It's not the investigation, it's not the trial, it's the victim in the center and support to her and her. First, I just want to bring you in because you've been part of this journey, and there was a big campaign that started around 2015 against the two-finger test. Um, it's been a couple of years now that the ban on the two-finger test has come into place. And what is your experience? I would like you to speak both in what is actually happening in hospitals, but also how courts are looking at the two-finger test or how they interpret this whole understanding of the two-finger test.
Just to add to one thing that Jacinta said, and I think that's very crucial, is that we understand, as she rightly said, that treatment is of paramount importance, right? A child or their parent may or may not consent to a medical examination. That a doctor cannot conclusively say if a child has been sexually assaulted or not. And I think that is very critical. And that is something that we have constantly worked on when we've done judicial training, when we've done police officer training. Because, earlier in the early days, I used to get calls from police officers who used to say, madam, medical test negative hai, matlab bachchi ke saath kuch hua hi nahi hai. So even to understand that a medical examination is a physical medical examination, and then there is a forensic medical examination. So a forensic medical examination can only be conducted in the event that the sexual assault is penetrative in nature and within a particular time frame. And the physical medical examination may not be even necessary in certain cases. If a child has been touched, if a child has been stalked, if some pornographic material has just been shown to a child. So all of that will depend on the nature of sexual assault or the nature of sexual violence that the child has been subjected to. So I think that's why it's very important that medical practitioners, medical officers, not only in district hospitals, and I think that's another big problem, right from primary healthcare centers to the district hospital, are sensitized and trained as to the kind of medical examination you need to subject the child to. Because if you see the medical performer, the examination performer, one of the first questions after taking consent is the nature of the assault. So when you understand the nature of assault, your examination is based on that. So don't subject a girl to an internal examination if she has just been touched. From our experience of working with girls and boys, we always imagine that the process at the police station would be the most traumatic for them. But some of the stories that we've heard at hospitals have been even more traumatic for them. So I think that it's very important for us to focus that there is in every district not one center or one hospital that conducts this examination or is trained in conducting the examination, but hospitals at every level, including PHCs, are equipped, the nursing staff is equipped to conduct this sort of an examination. And judges, I feel, are slowly understanding that a doctor, though the law is very clear that the doctor is only one who gives expert opinion, judges are slowly understanding that a doctor cannot conclusively stand in a witness box and say that this child has been assaulted. So medical evidence in that sense has several limitations.
And you're saying that courts are being more understanding.
I see a shift. I'm not saying they've reached the stage where they completely are on the same page, but there is definitely a shift in that for sure.
And you make a very valid point about that there should not be a special hospital that only one hospital will conduct these tests, or there'll be only one unit within the hospital who will conduct the test. It should go down, it should seep down to every level. And I think that's a very important point, because currently there is a campaign to promote specialized centers which will have all the equipment and will have the best forensic, but there will be just one in the district. And the fear is that how will victims reach this place? How will they access this place? And what will happen then to people who cannot reach there? And so we need to kind of weigh the pros and cons and also understand that it should seep down to every level, and at every level, support to victims, especially medical support, should be provided to the victims as soon as possible. Coming to my next question, Jacinta, and this is something Majlis has campaigned tirelessly for, which is the victim compensation scheme. And this comes from an understanding that yes, punishment is one aspect of the criminal justice system, and it's very accused focused, whether he should get punished or he shouldn't get punished, whether he should be convicted. But what happens to the victim? And one of the major things that we have seen through our experience is that victims, as soon as an incident of sexual abuse is reported, there's a lot of repercussions. Mostly they leave their home, they leave their school. There is so much of shame involved in reporting that they literally have to start life and research. And because they're so vulnerable, they're probably out of work, out of school, and the whole transformation requires a lot of financial support. Today, we have a national scheme for victim compensation, thanks to the Supreme Court. Maharashtra actually has been one of the forerunners, and before the national scheme, Maharashtra had a scheme called Manateria. Majlis was in fact instrumental in drafting that scheme. It has gone through, it's called the earlier scheme. It's been, I think, 2013 is where we got Manateria. Today it's 2020. What's your experience with the victim compensation scheme in Maharashtra? How is it working? How is it helping us?
So, Audrey, the earlier scheme, I've seen, we have data where victims have received compensation. But in the recent, the new scheme that has been introduced, we have not had such great, success. We have observed that victims do get their initial interim compensation, that is some 30,000 rupees. And after that, it's a big struggle. So we have tried going to their office, trying to meet people to understand why. And in one of our cases where we went, we had not such a good experience where, the child was, and the child's 4-year or 5-year-old victim, and the mother was called. We went as support persons to be there with the family, but we were told not to come inside, and we were waiting outside. But the same questions. It was like an interrogation happening. Asking the mother, so what were you doing? Where were you? When did it happen? So it was not such a good experience. And after going through that, also the child did not receive more than 30,000. And this is a case which happened last year. But even now, we are struggling to actually get them some benefit. And the victims get in the police station when they are, they take details for the compensation to fill in. The police fills the details. There's a hope, like we will get something because, as you say, there's so much of struggle. They need this kind of money, which they're using it for the child's benefit. But we've not had such a positive result. And I've not come across a case where we are working with that who has received more than 30,000 last up in the new scheme.
So a scheme that was meant to rehabilitate victims, to help her rebuild her life, has failed victims completely?
Yes. That's the reality of the cases that we are dealing with. But yes, that's the reality.
Versus, I think now I'm coming to a very crucial sector, in which I think most of our participants are also curious about, which is the court. I know that it is an institution that we all fear, we are terrified, we don't know, so all our information comes from television series. Can you just elaborate about what really happens once a case goes to court? What is the interaction of victims and what happens to them?
So, Audrey, I think in a case of child sexual abuse, after the FIR is filed, there's a lot of activity, so to say. So as Jacinta mentioned, you have the medical examination, the medical treatment, you will have the spot panchnama, you will have TIP if necessary. So you have 3-4 important interventions, the 164 statement, and then basically the police has to investigate the case and file a charge sheet within a stipulated time. Now, what tends to happen is there is activity that is going on, but the victim is no more, the child is no more the focus of that activity. And because the family is not aware of what is happening, they tend to believe that nothing is happening in my case. Whereas actually the investigation is going on, the accused is in all likelihood applying for bail, the charge sheet is being filed. So there is work happening on the case. So I think one of the very crucial roles that if you really want a child and their parent or whoever is supporting them to depose in court exactly what they did say to the police, supporting them during this 1.5 years phase is the most crucial. Because if they feel that their case has fallen off, if they feel nothing is happening in their case, then really when they are summoned to court, say a 1.5 years later, they have either been pressurized by the accused or they have a feeling that nothing is going to happen in my case. So I think as support persons, the CWC, the police, it is really the role of every stakeholder to keep the family informed about each of the legal steps that are coming or that are going to come. As far as court is concerned, I think, as you rightly said, one of the fears that even children and their families shared with us early on in the case is that mera case na 10 saal ki baat hai. When my daughter gets married, that is the time she will have to come to court to divorce. And these are genuine misconceptions that people have. Of course, the POCSO Act in theory says that the case is supposed to be completed within a year. And earlier on, in the first year, we had a lot of success where cases were completed in 14 months, 12 months, 16 months. But slowly, because of the number of cases increasing, reporting has increased, we have seen that cases are taking much more time. So you will have some cases which take longer, but on an average, I would say a POCSO case takes between 2 to 3 years. So to explain that to a victim and the family is very crucial. And also to explain to them that you don't need to hire a lawyer. The state provides a lawyer to you. I think that is very critical. As far as court is concerned, there are a lot of beneficial provisions. The victim is not supposed to come in contact with the child. Questions and cross-examination are not supposed to be directly posed to the child. So there are a lot of beneficial provisions. But I think it really depends a lot on the individual judge, how best they can ensure the protection and the dignity of the child during recording of the child's statement. One thing is for sure that the proceedings are in camera. That is one thing that happens across the board because it used to happen prior to POCSO and even now. But as far as making the child comfortable, ensuring that the child and the victim, the child and the perpetrator are not in contact with one another, I think those are very, very critical things. The child has to identify the perpetrator during the evidence to say that yes, this is the person who committed the sexual offence on me. But in the middle of the child's examination, if you ask the child to identify the perpetrator, then the rest of the examination, she's going to be traumatized. So these are small things that with training, with a lot of awareness that has gone into preparing the judiciary, I think has changed. There is a certain, I would say, a great deal of improvement. I remember prior to POCSO, in one of my earlier cases, when I had asked a judge that the defense lawyer should not directly ask any questions to the child based on the Sakshi judgment, he had said, "Madam, wo sab Supreme Court mein hota hai. Yahan pe aisa kuch nahi hai. The defense lawyer will directly question the child." But today we've seen a change. So the fact that it is now in the statute, the fact that there is much more awareness on the POCSO Act, we've seen that there's a change. Also, I feel infrastructure is in a way overrated. Because we have seen judges who have used, curtains around the witness box. We've seen judges who use cupboards to prevent the perpetrator and the child from coming in contact with one another. So when we talk about child-friendly spaces, it doesn't mean, a red wall and toys or chocolates. It means creating a safe space for the child. So you might provide the child some chocolates, and you might, have nicely painted walls, but the moment the child sees the perpetrator before her evidence, she's going to, completely lose track of what she came to say. So I think that level of sensitivity is required. And when we say child friendly, the hope is to make courts much more friendly. In Bombay, we have one child friendly court, but there are several courts that are handling POCSO matters. So even though there may be single spaces that are infrastructurally child friendly, it is not necessary that the judge in that court is child friendly. So I think it's more attitude. It has more to do with an attitude and your behavior rather than just a space that you create.
Can you talk about any case that you have seen where a victim was made to feel comfortable by proposing, and what you believe was that experience for the child? What made that change?
So, I've seen several cases where victims have been made very friendly by judges, have created a very friendly space. Couple of cases that come to mind. One of the cases that comes to mind was a 4-year-old girl who was extremely scared, couldn't speak, and the accused, the perpetrator's lawyer was one of the most well-known criminal lawyers in the city. And of course, her mother was very worried. We were very concerned. But the judge, called her to chambers because she didn't want her to depose in this big courtroom. So she called her to chambers. She spoke with her. What did you eat? What did you not eat? So the judge spent about 45 minutes just chatting with the child. And after she finished chatting with the child, this was during her lunch break, so the judge didn't take her lunch break. And then when the session resumed post-lunch, that's when, the perpetrator was called in from the back. He was made to sit behind the cupboard, so the girl didn't know he was there. And the child's evidence was recorded. A child who was very scared, a child who was traumatized. It was 2 years after the event that had taken place. And she answered every question that was put to her. And the judge was so proactive that every time the accused lawyer tried to ask the question, she said, "Would you remember this if this had happened to you 2 years ago?" So every question that he tried to ask or challenge the child, she would just not allow it. I've seen cases where judges have told the children that come back on another day. It's just not a good day. Like, we all have our good and bad days, and this is the first time the child is coming to the court. And coming back the second time, when the child is familiar with that space, the child is able to depose. So I think that yes, when there are sensitive people, when there are people who understand that with children they have their good days, they have their not so good days. When there is that understanding, and if the quality of the child's evidence is important, because you really don't have anything much else in the case. So if the evidence of the child is of good quality, then the chance of a conviction is definitely much more. And this is one thing I keep telling the police. I say that if you want a conviction, because the police are conviction driven in that sense, you're going to have to provide other support to the child. It's only if you provide that other support are you going to get quality evidence, and then your chances of conviction will increase.
Wow. It's interesting that you bring up the fact that it's not infrastructure or money, and that's really something that Majlis has been saying for a very long time, that it is a mindset change, it is a sensitivity, it is a centric approach that is what is important, and not expensive gadgets and red color courtrooms or fancy chairs, but just a mindset change that you genuinely want to be there and support them through this extremely difficult journey. I'm just going to have two final questions to both of you before we take just one of the questions. Just though we have a lot of people in our midst who are not lawyers, they are not social workers, but they are people who want to help. They want to do something. What would you like to advise them? What would you like to tell them? What can they do to contribute to this issue?
I would I need a clarity on the question. Support in terms of being with the child as a support person. Like as Percy said, like all the stakeholders need to be very sensitive, and we've seen that we have worked as support person, and how from the time the child comes, a fire is filed and the statement is recorded, and then how slowly the child gets comfortable to even, there's a lot of fear of the court, as persons mentioned. Medical sometimes can be, the fear, and then the stress that there could be some threat, the accused may reach out after a bail, etc. It is for us all to get together and provide that support and make them comfortable and stand with them and walk this journey with them. And also, when we're walking this journey with them, we also to ensure that they are walking this journey with dignity. Because many a times, when some stakeholders are not sensitive, it can make them feel, because there's shame attached to it, right? Because, this has happened to me, and then what will people say? So our experience has been, when you walk this journey through sensitively, being there with them, hand-holding them through the process, and maintaining their dignity, we all could contribute towards that. And I'm sure, we have seen success, not only conviction, but also in their personal life, to start living their life with dignity and putting this incident behind.
Mrs. I'll ask you the last question before we open it up to the audience. What does transforming a victim into a survivor mean for Majlis?
I think when we started out, Audrey, there was a lot of focus on who is a victim and who is a survivor, and everyone was caught up in the terminology. And I think one thing is very important to understand, that a victim doesn't automatically become a survivor if you call her that, right? It is this journey from a victim to a survivor. So a lot of children come into the system as victims and continue to be victims, because even though they may have got a conviction in their case, they have not been able to overcome what has happened to them. They don't feel a sense of justice. They don't feel a sense of closure. And I think when you talk about transforming a victim to a survivor, it means being with her at every step. So providing the necessary legal support to her, from the FIR to the judgment, that is helping her interact with every stakeholder. Because a victim comes in contact with the police, with the CWC, with the magistrate, then with the prosecutor, then with the judge. So there are so many people around. So you literally become the focal point that helps her with these various processes, simplifies the process to her, keeps her updated, provides her with that knowledge. But more importantly, to ensure that this journey you are able to overcome these various social hurdles. So whether it is a financial hurdle, whether it's a mental health issue, whether it is an issue of shelter, medical, social stigma, whether we've had cases where we needed to provide them financial assistance. So understanding the requirements and understanding the justice for each victim means something very different. So keeping her as the focus and trying to understand that for her what would be justice. It might not necessarily be a conviction. To some victims, a conviction is very important. But to some victims, just empowering them in this process brings about a great sense of closure and transforms their lives.
Thank you, Mrs.
can take the Q&A.
Yeah, we are actually completely out of time. It's 6 o'clock. Do you have any? Maybe we can take one or two questions. So I'll read I'll read one of the questions. It says, since 2018, the limitation has been removed. So does that mean an offence that was inflicted before 2012 is also covered under POCSO? As in, the victim is an adult now. Would you like to answer that question?
I think there is some sort of discussion around this issue even earlier. What is important for us to understand is that the POCSO Act, and for that matter, no act, can be applied retrospectively. You have adult survivors who report cases of child sexual abuse, that they've been abused when they were children, but they would have to have been a child, and the abuse would have had to have happened to them after the POCSO Act came into being, that is in 2012. So only if the person was a child, when as in the offence happened, when the person was a child and the POCSO Act in 2012 was enacted, only then. So for example, if a person is 20 years old and something has been happening and they've been subjected to sexual abuse for the last 8 years, 9 years, would mean that definitely the POCSO Act would be applicable. But if someone says that 30 years ago, 25 years ago, I was subjected to child sexual abuse, an offence can still be registered, right? Because you have the Indian Penal Code, but the POCSO Act will not be applicable. So what would be important to check was, even if it's a continuing offence, when did the offence take place, and when the offence took place, was the victim a child, and was the POCSO Act enacted?
Thanks, Mrs. I think that was very clear. We'll take one last question. It's an anonymous attendee who wants to know that if a teacher or any other individual who is not a family member reports the abuse, can they be anonymous? Will they have to be involved in the process of the case? Any of you can answer.
I think for us, what we've always tried is that because, as I said, reporting of a case of child sexual abuse is just the beginning. You would want the child to support the case, you would want the family to support the case. So what would be the ideal situation is to work with the child and the family to convince them on the importance of mandatory reporting and why they should report the case. I think that is very critical. The POCSO Act doesn't put a time limit that the moment you find out within 48 hours or within 24 hours, you have to report. So understanding you could take some time to convince the child, to convince the parents, to create a safe space for them, to provide their options for the child and for the family. That being said, if that can be done, then definitely the parent or someone from within the family can report the case. But if that is not possible, if they are not convinced, then there is definitely, you will have to report the case. When you report the case to the police and an FIR is registered in your name will be disclosed. So in that sense, you can't be completely anonymous. There is a child line helpline, 1098, that is an all India helpline. So you don't have to walk into a police station alone. You can seek the help of Childline, you can seek the helpline, you can seek the help of any local NGOs, the child welfare committee. So there are a lot of avenues of support. You will not be alone in this process. That is something that is sure. So you will definitely have a number of organizations and a number of people who are knowledgeable on this issue to assist you. And after that, your role is limited. After registration of FIR, you will have to come to court and depose. But you will not be constantly called to the police station or constantly called to the court. It will be a very limited interaction with the system that you will have.
Yeah. And I do think that, this is such a grave issue, and we have all let our children down in some way by not knowing what to do. And I think Child Safety Week is a really important time to make a pledge that we will do something, we will not keep quiet. And I think that is the important statement. And when we as adults come forward and do that, we will find the support at every stage of the case. I think I'll just take one last question because it's come up a lot of times. What has been the situation during COVID? How has Majlis been able to help victims during this very difficult time? I'll ask Jacinta to answer that question.
So during the COVID period, of course, we have had cases, and we have been successful in filing cases in the police stations. The police has called us to say that we need support to record the statement, because in one of the cases the child was challenged, a special child, and they also said that we will send you the van and get the statement recorded. You please come, because they needed a support person. And we've also got help from Child Welfare Committee, where in one of the cases where 3 children during the COVID time, there was a fear would have been, trafficked or got involved into some, trafficked. So we did get support of the Child Welfare Committee, and we got all 3 children admitted to a shelter home, wherein the police has also been very instrumental in helping us take the child to the hospital. And because it was locked down, we need that kind of support. They have provided that, and the children were admitted in the shelter. So even during COVID time, we received that kind of support from the state stakeholders. To answer the question.
So I think we have come to an end to our session. I think it was really interesting, if I have to say so myself, because I've done this work for 13 years, and yet when my colleagues were speaking, eyes were welling up, because it's just so emotional. It is so difficult, and yet we have to plow through. We have to push through and ensure that it happens. Child Safety Week is an important initiative, and it kind of sends a very clear message that we need to stand up. And I thank all the organizations who are part of this process, who are doing this amazing work. And I ask each of you to, as participants, as supporters, to support in every way that you can. And there are so many ways that you can support to be part of this process. I just have to say that there is a lot of fear of the legal. We are the least appreciated, least engaging arm of the whole process, where people are ready to provide all the other services, including counseling, including prevention, including a lot of awareness. But when it actually comes to reporting a case and walking that journey, it is the most feared. But to fear us here, and our whole team who is behind us will vouch for the fact that it is an extremely empowering journey. And I encourage each of you to start somewhere and do something for children who are facing child sexual abuse. Thank you so much. This is Majlis who has conducted this session. I thank Persis and Jacinta for doing this with me. Have a great evening.